Welcome back to Go Gaddis Real Estate Radio right here on AM 920 The Answer. We want to connect with you, and don't forget, it's really easy. Go to gogaddisradio.com. That's GOGADDIS radio.com. You can make suggestions. You can ask questions. We answer on air, off air. You can subscribe to our podcast. Watch our videos on YouTube. You can do pretty much anything. And I want to say to everybody who is sticking with us, welcome back. We're talking with a closing attorney and a really good friend of mine, Joe O'Kelley, who is the managing partner of O'Kelley Sorohan, about what happens when more than just an individual, just a natural person is buying or selling property. You know, if you think the paperwork, this type of paperwork is boring, just wait until you hear how the wrong paperwork can derail a sale, leave you open to lawsuits, or even cost you thousands. So, Joe, in our last segment, you were talking about who would sign if you had put a property into a trust. So, for example, the last property you sold for me, I had put it into a revocable living trust, I think it's called. And so when it was time for me to sell, I had to provide you with a copy of the trust agreement that showed what I had the power to do on behalf of that trust. And is that what most everybody should be expecting if they are selling property for a trust?
Yeah, it names the trustee in that document, and the trust agreement sort of lays everything out.
So in mine, it must have named me as the trustee.
That's right.
Okay, got it.
And you would hold property as the trustee of the trust.
So in other words, the property, if I bought it, it would be transferred to Cleveland M. Gaddis as trustee for the Cleveland M. Gaddis Revocable Trust?
Correct.
Interesting, because then you have to prove I am Cleve Gaddis, and then separately you have to prove that this is the Cleve Gaddis who has the authority to do it based on the trust. Very, very interesting stuff. Interesting.
I don't know that it's like that in every state, but it's like that in Georgia.
Really?
The trustee holds the property in Georgia.
The trustee holds the property itself. So in other states, could it be the beneficiary holds the property or something like that? I guess not. Then it wouldn't have any privacy or protection.
Some states just name the trust, XYZ Trust.
Got it.
And ours is different.
And then you have a trust document that does that. Okay, so let's hit a few real scenarios if you don't mind. Suppose we're dealing with an estate, maybe a situation where a parent passed away, and then the kids want to sell the house. What do they need in order to be able to do that?
Ultimately, they need letters testamentary that are handed down from a judge after they have probated the estate. So, person dies.
Yep.
They have a will or they don't have a will.
Okay.
So, with a will, they go and probate the estate, which means they go to the judge basically and say, we want to sell the property. We want to be named the executor if they're in the will, or co-executors, whatever the will says.
Mm-hmm.
And then the judge will issue letters testamentary, and the letters testamentary will describe what the powers are. Remember, we always have to have the powers.
Mm-hmm.
And we'll name them as the executor or executors or co-executors, and then that's who has the legal authority to handle the estate. Then the estate transfers out of the deceased person, and then the estate gets the money, and in the will, it tells what the executors are supposed to do with the money. We're just converting an estate asset, land and home, into cash, and then the executor can do what the will says to do.
And so the executor and the estate itself are two different entities. So it's the judge, you're saying, let's just say somebody died in Gwinnett County. It's the Gwinnett County judge. And is it probate court? Is that what it's called that you go through? The judge issues, you're calling it letters testamentary, that says, here's we're setting up the estate and here's who has the power to do what. And I would assume there's also instructions about how the money should be divided up among the heirs if there are multiple heirs. Is that correct? Would that be normally in the letters testamentary from the judge?
No. It would attach, it'll say with will annexed. If there's no will, then it's administrator.
Oh.
Okay. And it's letters of testamentary, I think.
Letters of testamentary.
We call it letters testamentary.
Well,
and,
I got my law degree at Norcross High School.
Well, I can't remember myself because we use the short term so much.
Yeah.
I'm trying to remember here. Sometimes there's no will attached.
Yeah.
And so you can't have an executor if there's no executor name. So somebody, one of the children or somebody, brings an action to the judge and says, I want to administer this estate.
Yep.
And they become the administrator of the estate versus the executor of the estate.
Yeah. Interesting. So let me give you a different scenario. I know you're not a tax lawyer, you're not a CPA, but I think you've probably experienced this at some point in time. So you have a parent who decides, hey, the way I'm going to make sure my property passes to my son, and let's just say it was an only child, or let's say it's a daughter in this case, is I'm going to go ahead and put my daughter on the title of the property. I just bought it this in 2025, and I paid $400,000, and I'm going to put my daughter on it. Now, I pass away 10 years from now when this property is not worth $400,000, but it's worth $800,000. In my opinion, that daughter could be subject to some taxes because of the way the deed was done that wouldn't necessarily happen if it went through probate and the daughter inherited the property that way.
Yeah.
Do you agree with that? Because technically, the daughter's basis would be $400,000, and if she got the property at $800,000, she might very well owe estate tax on $400,000.
Absolutely. It's called stepped-up basis.
Yep.
Before we get there, though, just think about, people do that a lot, and they think that makes sense. But you have, let's say you have a young daughter, and you died sooner than 10 years. And so, or you have a young daughter and she gets into trouble and she's on property, it gets attached, right?
Yep.
You know what I'm saying?
Yep.
So you got to think about that smaller issue than the stepped up basis that you're talking about. So on a stepped up basis, when you die in 10 years and the property's worth 800 and it goes through probate, your daughter, being the one who's going to get the property, would get it with an 800,000 basis instead of 400.
Right.
Could immediately sell it and have hardly any tax, or sell it for 800 and have no tax. That's what the stepped up basis.
Exactly, which makes sense. I've also heard people get in trouble by, as a parent, saying, let me put my child on my bank account. And then the child gets themselves in financial trouble. And next thing you know, somebody's coming and taking money that's out of that joint account. So there's a lot of exposure that happens when you put somebody on the deed to something. So in my opinion, and you correct me if I'm wrong, Joe, I think it would make more sense for somebody to either put it in the will, do those types of things. You can have I think you can do a beneficiary thing on death, meaning I have to die and then my account becomes the property of this person. So there's probably lots of ways to do that. So let's jump into a different subject though, and this is divorce. This is a messy one. So in the case of a divorce, who determines who can sell what and make decisions and sign? I mean, how does it work?
So in a divorce action, again, you're going to a judge and they will issue a decree. All of these basically are decrees that are signed. So there's a divorce action. Let's say they agree to the terms. They still have to come up with an agreement and it has to be signed off by a judge.
Right.
And if it's not, and it's contested and same decision, they'll go through a trial, and then the judge will make the decision and issue a divorce decree.
And then you, as the attorney, have a copy of that divorce decree, and you're following the judge's instructions.
Absolutely.
So 100%. If a judge says Mary and John or whoever it is are getting a divorce, and Mary's entitled to 50%, John's entitled to 50%, then you're going to follow the judge's instructions.
That's right. And if they want to go off book and change it, we won't do it unless the judge comes back and says, yeah, you can change it.
Oh, so even if they sign something together, say, no, we've changed our mind, you're going to be required to follow the judge's orders.
Not 100%.
Okay.
We say 100% because the lawyers could get involved. They could all agree and do something separate. But you want to stick to the rule as much as you can. And the rule would be, okay, y'all want to change it, go change it and get the judge to tell you it's okay.
Yeah.
So I don't want to go off book. Let's just stick with that one.
Sorry, I sometimes go a little too deep, don't I? So divorce, you need the divorce decree from the judge. That's going to describe what happens. Okay, now you have an LLC, and this LLC has two members, and they both own 50% of the LLC. One of them wants to sell, one of them does not want to sell.
Yeah.
Can they sell?
What happens is it all depends on what the operating agreement says. There's usually a deadlock provision in the operating agreement that should contemplate a 50-50 disagreement.
Right.
I happen to be in an LLC that doesn't have a deadlock provision, which means 50-50, we square off. And so if it was two individuals, one could sue for partition and say, buy me out or sell the property.
Yeah.
I don't know the legal maneuvering in that, but it would be the similar kind of structure. You're going to have to, because no one had the deadlock provision written in advance, they would have to fight, just like you would in a partition action for individuals would be similar to a fight.
Yeah.
Oh, you don't want to sell? Then I'm going to go to the judge and say, you got to sell, or you got to buy me out.
So anybody you're going to become partners with, you need to make sure you have something that very, very clearly outlines those agreements. I think that is so very important. I think the bottom line is if you're buying or selling through an entity, a trust, or an estate, you really shouldn't assume. You need to make sure that your closing attorney, and we suggest it's O'Kelley Sorohan, reviews the documents with you and reviews them early. Joe, thank you so much for joining us today. I always appreciate you being here, and we have great discussions. And listeners, if you've got questions or maybe a story about buying or selling through a trust, LLC, or an estate, maybe, I hate to say it, but maybe a nightmare story, we'd love to hear it. Go to gogaddisradio.com, GOGADDIS radio.com. You can send us your questions. You can push back. You can share your ideas, anything like that. Stay tuned. When we come back in our Neighborhood Spotlight, we're featuring Oxford Mill in Johns Creek. And could it be that buyers are starting to sniff around online for real estate for sale at a number that is higher than in 2022 or 23? Stick with us. We've got that and more. We'll be back.